Well, good afternoon and welcome. I appreciate all of your coming today to hear our speaker who's come down from Sacramento to talk to us about what's going on in our organization, the only residents' voice in Sacramento, which is CALCRA. And many of you are members, and if you want membership information, it's on the back table with some other material. Margaret Christian has been president of CALCRA for quite a few years and lives in a CCRC near Davis, I guess, right? Not necessarily Sacramento. And she's going to tell us today, she has a short slide presentation that some of you may have seen before, but it never hurts to get another review. And then we'll have about 30 minutes or so for question and answers to ask about other things. I'm particularly kind of curious to know some we do have a bill, and Margaret can talk about the general things. It hasn't been officially introduced yet, but I think it offers us another opportunity to work on a set of issues that I think will be of interest to us. She can explain that, and she'll explain to us how our organization works in Sacramento with a lobbying firm, and how we can, as members of CALCRA, like we did last year, support our legislative bill by writing letters, making calls, etc. So she'll talk about a lot of that as well. Want to welcome our guest from the Towers, and our guest who's on the list to come into the Sequoias. So she's adventuresome and is wanting to really check out, and I think you're being very smart to learn all the details before you move into here. So thank you for coming. I'll turn it over to Margaret.
Thank you. Thank you all for coming in from the lovely, sunny, bright afternoon into this room to learn something about CALCRA. I want to talk about the law, which sounds maybe kind of off-putting, but the law really defines what happens with CCRCs in this state. There's the legislature, those famous folks in Sacramento who make our law. Then there are two state agencies that are involved with CCRCs and who enforce the law. Department of Social Services, which has jurisdiction over independent living, assisted living, and memory care services. The Department of Public Health, which is over skilled nursing. So I've often thought if you really wanted a difficult, very painful job, you should be an executive director of one of our communities. Because you have two different state departments, two different licenses to deal with, so you've got lots of pressure over your shoulder here telling you what to do. There are the providers who are supposed to comply with these laws. And the providers of our CCRCs are one of two types: nonprofits, represented by Leading Age. Some of you may have heard of them. They're a very active, very well-funded, nationwide trade organization that represents senior living operations. So they don't just represent CCRCs, they represent assisted living, they represent HUD housing, skilled nursing facilities, so they're quite a force to be reckoned with. For-profit providers call themselves the California Association of CCRCs, and they are currently represented by the California Assisted Living Association. And in California, as pretty much reflected nationwide, the preponderance of CCRC providers are nonprofits. They are slowly losing ground to the for-profit side of the equation. The development that's been going on in this state in CCRC industry has pretty much been by for-profits. So they're slowly taking a bigger and bigger piece of that pie. And finally, there's us residents. We depend on and live with the effects of all these laws. And CALCRA is really the only organization that solely represents the interests of residents. You will hear the providers, and especially leading age, say that because they represent the providers, kind of by inference, they also represent residents. But having worked with those folks over the years, I can tell you that when an issue comes up and the providers have one viewpoint and the residents have another, leading age falls on the provider's side. Shouldn't be a surprise. A little bit about our history. We've actually been around quite a few years. People are usually surprised to see that. We currently have about 2,600 members, and it's always kind of fluctuated around that number. There are approximately 25,000 residents, CCRC residents in California. We currently have about 110 communities. As I said, that grows by about 1 or 2 a year. Pretty slow, but pretty steady. CALCRA is governed by an all-volunteer board made up of residents from CCRCs in Northern California, Southern California, for-profit, not-for-profit. We have a pretty good mix, all volunteer. Our mission, quite simply, is to enhance the financial security and quality of life of CCRC residents. We try and do that by encouraging transparency and accountability in the operations of our providers, and chiefly by sponsoring and supporting legislation that we feel represents the interests of residents. We will also vigorously oppose legislation that we feel is not in our interest. We try and serve as an information resource to you all through our newsletter and our webpage. I'm not going to go through all of the legislative achievements, but you can see from this slide we've had approximately 20 bills successfully pass through the legislature and be enacted. I think for any of you who are familiar even a little bit with the political process in this state and have an appreciation for what it takes to get a bill turned into law, that's a pretty good achievement, especially for a small organization, certainly not lavishly funded. Our budget fluctuates right around $50,000 a year, most of which goes to our contract lobbyist. So the fact that we've been able to enact that number of bills into law, I think is a pretty good indication of how effective we are. Residents tend to look at lives in their communities as this is just the way it is, but there are lots of things about the operation of a CCRC and the rights of residents that simply would not exist if CALCRA had not been successful in getting a bill passed. And as I said, I'm not going to go through all of these. There's some more listed on the little brochure in back, and a very complete list on our webpage. But for example, you wouldn't have a resident council. You wouldn't have quarterly reporting from your provider on their financial status. You wouldn't have access to your provider's board meeting minutes. We established minimum liquid debt reserve service requirements. So you can kind of see the issues that CALCRA has been successful with in the past. I want to talk a little bit about some of our more recent bills. AB 1751 was signed into law in 2014, and that had 3 distinct elements. It increased the provider's financial reporting to you from every 6 months to quarterly, and required written explanation of all significant budget variances. It required providers to post their annual reports on their website so that they're more accessible to you. And probably the most famous or infamous section of this bill had to do with requiring for nonprofit providers a resident as a voting member on their board. SB 939 was actually a 2-year bill that started life the year before as SB 475. That had to do with repayment of repayable contracts. And I don't know if that's a contract model you folks have here, but for many CCRCs in the state, they offer a model that provides for repayment of a portion of your entrance fee when you either move out or die. What we were finding was that these repayments were not being made timely. The worst case scenario we uncovered was the family of a deceased resident had waited 5 years and they still had not received the repayment of that refundable portion of the resident's contract. Another thing that was happening was that some CCRCs, not all, were continuing to charge a monthly, what they were calling maintenance fee on vacated apartments. And that charge was taken out of any proceeds that came from reselling the unit. Well, I don't have to tell you, after the financial crisis, reselling units slowed down, and in a couple of cases, this monthly maintenance fee pretty much depleted any assets that the heirs were eligible to collect when the unit finally sold. So those were the two things that we focused on with this bill. There is now a definite time period set for when these repayments have to begin, and if they don't, monetary fines are assessed against the provider, and they can no longer charge a monthly maintenance fee except for establishments that have what they call equity interest contracts, and that's like a co-op. AB 713 had to do with transfers and levels of care. And before this bill went into effect, if my provider, he could come to me, my executive director, and say, you know, Margaret, it's time for you to move to assisted living. And I would say, well, I don't want to do that. And he would say, well, that's too bad. We think it's time for you to move. It's our decision. My only recourse would have been to appeal, well, not appeal, but ask the Department of Social Services to review that process that they used. And that process literally was, did they give me timely notice? Did they schedule appropriate care plan conferences? I did not have the ability to appeal the actual decision. And in the instance where there's a potential resident, say, interested in my unit, what do you think the motivation for my executive director would be? If he moves me to assisted living, he gets to charge me more money, and he gets a whole new entrance fee from this prospective resident. So he might be more encouraged to want to move me along. Well, this bill required that providers use an assessment tool. If they alleged that I was having cognitive issues that prevented me from continuing to live independently, they needed to do an assessment of my cognitive status and provide me with a copy of that assessment. If it was physical limitations, same thing. They need to do an assessment of those limitations so that there's some indication that there is a valid reason other than just their desire to move me along. I have the ability now to actually appeal the decision to transfer me, and social services has to consider the appropriateness and the necessity of the transfer in their consideration of my appeal. We didn't do so well last year. We had AB 3088, which would have required all CCRCs to obtain a periodic actuarial study and a written review of the buildings and grounds and support systems for the buildings. We got all the way through the legislature, 3 committee hearings, 2 floor votes, and only had 1 no vote. Thought we were doing pretty well. And at the last minute, the Department of Social Services decided that they were not convinced that actuarial studies were in fact the appropriate tool to assess the financial and operational strength of a CCRC. And they wanted more time to study that issue. In fact, they said it would take them 2 years to do that. And they were able to have that bill vetoed. And that was actually pretty smart on their part by saying they needed 2 years for further studies, so that meant we couldn't just turn around and reintroduce it this year because they would say they're not through studying it. Our legislative agenda, you would think that maybe with all the 20 bills that have passed and everything else that has gone on, that there's nothing else to do, but there certainly is. I think Regina has back on the table kind of our list from last year, and in our last newsletter, there's also the wish list that was recently approved by our board. These are just some of the issues that we want to pursue. Again, where the actuarial studies are back on the list, unfortunately. We think residents should get in writing a written notice of all complaints filed against their CCRC. The transfer of funds from a provider for any purpose other than the benefit of residents, although that's on our list, I got to tell you, I don't think that anything's going to happen on that in my lifetime. But that was generated by kind of an infamous example in Southern California where a large provider that has about 6 or 7 CCRCs decided to borrow money from those communities for an investment opportunity in Baja California. And to nobody's surprise, that investment opportunity just didn't work out, fell flat on its face. And the provider had the nerve to go back to those communities and say, you know that money you loaned us, well, we've decided it was a gift, so we're not going to repay it. And that just seemed like a pretty egregious thing to do. But so that kind of got that issue on our list. We'd like a clear statement of provider investment policies so that residents can understand that. We'd like to increase the requirement for the operating expense reserve so that it's not as long as it is now. For nonprofit providers, we've got several elements of good governance that we would like to see enacted in their operations. So you can kind of see that, CALCRA does not take the place of the resident council, which operates in each community to address issues in your home community. We're looking at issues that have a statewide implication that can be addressed by legislative activity. We think we've gotten a pretty good reputation overall in Sacramento, as small as we are, but we really need resident support. Not only the numbers, which certainly helps when we have to go to a committee to testify, but quite frankly, your money. We need the dues. Princely sum of $25 a year for an individual or $35 a year for a couple. We think it's a pretty good deal. I hope you do too. And with that, I'd be happy to take any questions.
On your slide,
Regina, do you want to?
Yeah.
Okay.
on your slide that...
Let me bring the mic to you. Let me bring the mics to you.
Sure.
Thank you so much, Margaret.
On the slide that you have for the Bloom legislation,
Yes.
it mentioned the variance on operating expenses. Can you go back to that? Yeah, that was it.
Whoops.
Significant budget variances, they give any guidance on that?
No, that's the language
Thank you.
in the statute. But the intent is, if there's a variance, that they should be able to tell you why. What elements happened that caused that variance?
Been tested in court?
No.
So I'm very new, and forgive me if I'm asking a question that's either A, inappropriate, or B, something that's been discussed. I would be interested in knowing, in the history of CALCRA, if any resident association was successful in contesting the % of increase on an annual basis.
Actually, my community was able last year to get the proposed increase, at least for assisted living, decreased by about a 0.5 percentage point. And I believe a couple of other communities have also been able to do that. To get to that spot, you need a finance committee that is well-informed and active, that can sit down and have an intelligent conversation with your providers about the reason that they're proposing to increase your fees. And it can't just be the cost of living is going up. They need to be able to show really some reason. There's a lot of wiggle room in the law. There's not a lot of very concrete requirements in terms of what their rationale has to be, unfortunately. But those kinds of discussions are very important. One thing that is in the statute is that every 2 years, the provider needs to engage in an assessment, a formal assessment of the quality of their engagement with residents during the budget planning process. And then they need to post the results of that assessment. So if they're saying everything's fine, and residents have a different view, that's often a good starting point for a discussion of the difference in opinion on that issue. There is also some, unfortunately, old information on the DSS website about history of fee increases. I say unfortunately old because their data comes from audited financial statements which are filed after the close of the provider's fiscal year. So I think, for example, their most recent year might be 2016 going on to 2017. But you can look at that and see not only what your provider has done, but what others have done for other levels of care and get a feel for other communities in your area, as well as statewide in terms of what the fee increases have been running. Mike, next.
Margaret, thank you for being here today, and thank you for all the work you do on behalf of those of us that live in CCRCs. Now, my question is sort of twofold. Number one, what more could you do if your budget was increased significantly? And number two, have you suggested to people that they might remember CALCRA in their wills and estate planning and trusts and things like that? I mean, what could you do if you were endowed a little bit heavier?
We haven't really pursued the whole endowment issue. One thing you need to keep in mind, and we are a 501c4. We are not a C3, not tax deductible. So, you know, that kind of has a big implication for people that are considering large gifts, unfortunately. But because of the lobbying and the political work we do, we are a C4. And your other thing is, what would we do with more money? We could probably ratchet up our presence in what they call the building, the Capitol. We could, put more legislation forward. We could consider possibly having a staff attorney. I I'm sure a lot of you are familiar with Canner and know that they have attorneys on their staff, and they are able to not only entertain complaints and concerns from residents, but they can refer people for representation if they want to pursue it. I think we could just have a more informed and more in-depth presence in the industry.
Let me add to that. CANAR stands for California Association of Nursing Home Reform. So our prospect here will know what that means. And I think all of us here had a presentation from Pat McGinnis, the executive director, a couple of years ago here. So, and I'm just going to put in a pitch. We're 501c4 because we're a political lobbying organization, and all of us in our professional lives and others have paid professional dues to have representation, to represent us in the workforce, etc. That's what CALCRA is, basically. It's our residents association lobby and advocate, and so those are like, that's the kind of stuff I say, well, that's in my self-interest. I need to support this. So I just want to put that pitch in.
Thank you.
Steve.
On the transfer to a higher level of care issue, our executive director, I don't know all the details, but he has talked about the legal responsibility imposed on him by law to move patients under certain circumstances. I don't know the details, as I said. I was just curious about this legislation that was proposed. Would it somehow interpose itself and protect the management of the institution from liability if something happened to the resident who management wanted to transfer to a higher level of care, but couldn't because of this appeals process, which, as you described it, I assume could go on quite some time since it required an ultimate finding by a agency in Sacramento.
Actually, those appeals should be relatively speedily processed. The Department of Social Services has geriatric or nurse practitioners and geriatric social workers who would hear those complaints. By the way, none have been filed. I would think it would protect, the law would protect both the resident and management by requiring an assessment of the element of the resident's living that would justify that transfer. If I'm a resident becoming involved in this, and I go through an assessment of my ability to live independently, that means, I would assume, that, for example, an occupational therapist has come into my unit and, we've gone through my daily living routine and they've assessed my ability to do that independently. So I've been through that. And the findings, not only would they be written up and made available to me, but I would know that, hey, I can't do this, and it's something that I cannot afford, or I'm not willing to have help brought in. So yeah, I may not want to, but I need to move. So I really think the assessment piece of that legislation is going to be helpful all the way around in terms of protecting whatever decision results.
I only ask because I believe almost universally people resist being moved, not because of any suspicion that the institution must make money off the resale of their apartment, but they just don't want to leave what's familiar and comfortable and go to whatever, assisted living.
Right.
Margaret, will you refresh my memory? What's the DSS document that this is in? It's called a order or something. They've written this up, and there's a something policy statement.
They have an
It's in something, so what's that thing called? It's an order, a policy statement that's issued that we can get a copy of.
Well, it's what they call a PIN, a provider information notice, and we included that, at the time it was published, we included that in our newsletter. So, and I don't remember the date, unfortunately, that would be another source.
Yeah, I think, circulated it here, but I couldn't remember the word PIN. So provider information notice is a document that comes out from the Department of Social Services when they issue a new policy like this.
Mm-hmm.
So there is I believe, a period of time for the appeal. I've forgotten how many days it is, but it's pretty short. And so that document is available on the Department of Social Services website under the CCRC page.
And Social Services has had related experience in this regard because in other RCFEs and other senior living communities that they oversee, particularly assisted living, it's not that uncommon for social services staff to come in and perhaps see someone who is more impaired than covered by that particular license and require, or say that they think the person should be discharged or moved. And that has existed for a long time, in addition to the ability of the resident to appeal that decision, and that's why that staff was specifically set up to hear those appeals. So those are the folks who would hear any appeals from CCRC residents. So I don't anticipate it to be a long, drawn-out process at all. And as I said, Department of Social Services has had experience in dealing with very similar situations. So it should go very well if it's ever put to the test. Hopefully it won't have to be, but we'll see.
Any other questions?
I'll ask another one. Margaret, on the sheet that we have that's legislative issues, number 2, statute that provides to have a fiduciary duty to residents. This is something that's you're hoping to do?
It is something we would like to see happen. How much luck we would have is a question in this state. There is a section of the Corporations Code that, and I can't remember the wording, but it prohibits recipients of goods or services from, say, a provider. It prohibits a fiduciary responsibility in that relationship. The way it's set up now is that nonprofit boards have, the boards of directors each have a fiduciary duty to the organization, to the provider. And that makes sense. That's their primary interest, is to make sure that the provider is doing well and compliant. So to add another fiduciary, possibly conflicting fiduciary duty to that could be kind of tricky. There may be some other ways we can approach that. But we very much want to see some kind of acknowledgement from the provider that they have a responsibility to residents equal to at least their responsibility to their organization.
Yeah, I asked this question of our board, or our CFO rather, a year or so ago, and he wouldn't acknowledge any fiduciary responsibility.
To residents?
To residents.
Right.
So I'm interested to see what you have here.
Yeah.
It sounds like you have to change existing law.
We may, or well, actually we were talking with Cantor a few months ago as we were getting legislative ideas together, and they indicated that they might want to pursue something along those lines. So I don't know if they've got anything for this particular session, but it's definitely on our radar.
Yeah. Thank you very much, and thanks for coming today.
I have a couple of other questions. One thing that we wanted to cover in general, we talked about that our bill last year, got through the process up to the governor's desk and was vetoed. We can't reintroduce that bill because the department is technically going to study it for 2 years. So we will need to get it on top of the department. But Margaret, you can talk in general terms about a bill that we're hoping to have introduced this year. You probably know that this is the beginning of a 2-year legislative session, and there were something like, I don't know, some huge number of 2,500 bills introduced that have a 2-year time frame to go through. The deadline for introducing new bills is in March, but if that passes, what one does is you take a bill that's been introduced and you substitute new language. It's called a spot bill. So we have a spot bill, and we have a legislature that would introduce this bill. We can't talk about it right now because it hasn't yet officially been introduced, and that's up to the author to introduce it and release that information. But I think you can talk in general terms about what the subject matter of that bill would be.
Right, what this bill would focus on, there are two things. One, the current legislation talks about the Department of Social Services being able to step in and require a provider who they determine to be financially, maybe not insolvent, but questionable, to require that provider to give them a corrective action plan. And they will monitor the situation. They've never really done much more than that. This bill would still leave it up to the discretion of social services, but it would list several criteria for them in considering whether a provider is getting shaky. For example, occupancy falling below 90%, and I can't remember the other two conditions. But the other thing it would do is it would make that and the subsequent corrective action plans available to residents and prospective residents. And we think that's very important information for residents to have. We don't have access to it now, so nobody would know. Say, for example, if this facility was under corrective action plan for financial solvency, you'd never know. So that's one part of the bill. The other part would address what's called the Provider Fee Fund, which funds the actions and activities of the continuing care branch at Department of Social Services, which oversees our providers' financial situation and our contracts. And it would change the way that fund is calculated, and it would require the budget for the continuing care branch to be posted on the DSS website, which it is not now. So again, both of the elements of this bill are kind of geared towards more information for residents in terms of dealing with the providers and the department in terms of their oversight activities.
I have one other thing. Over lunch we were talking about something of just general interest because we're nosy neighbors. Our neighbors at the Carlisle. There's a lot of rumors floating around about what's going on. I happen to have a friend who's on the board, and their litigation is kind of heated up, and so that's good. But there's another part I wasn't aware of, and Margaret had mentioned that they're going the litigation route, but the other route they could go would be to file a complaint with the Department of Social Services to basically challenge the certificate of provider certificate, or whatever you call it. So do you just want to make a comment about what that means and what's happened?
Yeah, several months ago there was a pretty lengthy article in our newsletter about the situation with the Carlisle and their class action suit, and the fact that in addition to the class action suit, they had filed a complaint with the Department of Social Services regarding some of the elements of that class action suit that had to do with the status of their building. And the department's consideration of that complaint has been completed. 3 of the 4 issues that were raised in the complaint were found in favor of the residents. So I'm not a lawyer, as everybody likes to say, but I would hope that that would have some kind kind of good vibes for them going forward in terms of how the resolution for their class action suit, which is continuing. But I think it's a good thing, just as an example, that when things come to that unfortunate pass, as they have at the Carlisle, that in addition to considering legal action, you do have the option of filing a complaint with social services. And they were quite smart to do both, I think.
Are there any other questions people would like to ask? One more.
Do you see any change in things with new administration, with Governor Newsom there in the seat?
For us, no, I don't. I wish I did, but we are such a small element of the Department of Social Services and the governor's portfolio of it. I don't know that we'll see any changes from Newsom that would actually trickle down to CCRC.
That kind of leads me to ask a kind of a follow-up question. Since we're introducing legislation this year, and we do have a new governor who has quite a robust agenda, what is the, what are the chances that our bill will just kind of get lost in the shuffle because, just the immense number of bills have been introduced and the chance that this governor is going to move on housing and some other large topics. I think there was already 200 bills just on housing.
Well, that's what our lobbyist does. And, when we get a bill going, we meet with everybody concerned on all the 3 committees. And last year, like I said, given our record in the legislature, we thought we had a pretty good deal going in terms of getting a signature from the governor. Unfortunately, the department kind of outmaneuvered us in terms of their access to the governor's office and being able to get support for their position to oppose it. I've never seen that happen before. I hope I never see it happen again. But, generally, if you do your homework through the legislative session and through the process and you have the support, it should go through. Fingers crossed.
Steve has another question. She's got a microphone coming.
You keep going and we keep thinking of more.
That's okay.
Can you tell us who your lobbyist is and if it's an individual or a firm, if they represent other entities that are like CALCRA?
So our lobbyist is Hernandez Strategies, Inc., run by a fellow named Ignacio Hernandez, and he usually has 1 or 2 staff people working for him. As far as I know, we are the only senior emphasis group that they work with. They do a lot of consumer action, consumer protection work. They've been very successful with us so far up until this problem we had last year. Because they not only have to take on and support our bill through the legislative process, they also look at all those 2,500 bills to see if there are any that would possibly impact us that we should wake up and pay attention to. So they provide a pretty broad range of advocacy services to us for not a very big payment, fortunately.
I think we've come to the end of our questions. I want to thank Margaret for making this trip down from Sacramento to be here with us. And I want to thank the CALCRA members who are present today and hope that people will remember to pay their dues if you haven't. Margaret will take a check from you today, or you can stick it in the mail to Mr. Hale, and he will do that. So thank you so very much.
Thank you for coming.